Let's see what we have today on the Kick in the Tires podcast.
Today, we're shifting gears a bit. We're diving deep into a really significant legal fight. It's between two well-known teams, 23XI Racing and Front Row Motorsports, and NASCAR itself. And specifically, we're going to dissect this recent judge's ruling. He denied their request for what's called a preliminary injunction. So what were they actually asking for? Why did the court say no, at least for now? And what's next in this legal battle?
What's really fascinating here and what you need to grasp is that this isn't just some, minor squabble over a penalty or a rule infraction. This case goes right to the heart of the sport's foundational agreements. It touches on core business practices, competition itself, and the whole framework of professional stock car racing. It's really about how the rules of the game are being set and enforced, not just on the track with cars and strategy, but with contracts, big antitrust claims, and these major legal challenges. This is way more than a pit lane argument. It's like a fight over the sport's actual blueprint.
Absolutely. And it seems like this whole legal challenge, it really boils down to one core concept, these NASCAR charters. Now, I get that they're like the lifeblood for a team, but maybe for everyone listening, could you break down what exactly these charters are? Why are they such a fiercely contested asset?
Right. So you can kind of think of a charter as the ultimate golden ticket in NASCAR. But honestly, for the teams, it's much more than just a pass. It's really the bedrock of their whole business model. They were introduced back in 2016, came out of negotiations between NASCAR and the teams, and basically a charter guarantees a team gets one car into every single Cup Series race. Now, when you're running a multi-million-dollar operation, that's not just a nice to have. It's absolutely foundational. You need it to attract sponsors, get top drivers, ensure some kind of financial stability. Without one, you're basically scrambling year after year. It's a tough position.
So if a team doesn't have one of these charters, are they just completely out of luck? Is there any other path to compete in the Cup Series?
Well, they're not completely shut out now, but it is an incredibly steep uphill climb. Almost impossible to do consistently, really. Teams without charters run as what they call open cars. That means they have to qualify for each race on their own merit, week in, week out. But here's the reality check. Since this charter system started, seeing an open car compete consistently across a whole season, it's been effectively non-existent. Just imagine the cost. Prepping a car for every race, traveling, everything, but without the guaranteed prize money, without sponsor certainty, maybe not even getting a spot on the grid. It's a huge financial risk, a massive logistical challenge. Very few can sustain that.
Right. And I've definitely heard NASCAR mention that these charters were initially given out for free back in 2016. Is that really the full picture?
Yeah, that's a really key point of contention in all this, and you definitely have to look deeper. While it's true, teams didn't write a check directly to NASCAR for the charter itself. Calling them free is, well, it's misleading at best. Think of it like getting a free lease on a prime shop location. You didn't pay up front, but you're still on the hook for rent, operating costs, upkeep, right? These charters came with really significant obligations for the teams. Things like operating requirements, sponsor exclusivity deals, how they could use their intellectual property. All of that imposes real substantial costs on the teams. And at the same time, it provides huge benefits and stability back to NASCAR. So it was much more of a complex bargain, not just a simple giveaway.
Okay, that makes sense. And this complex agreement, it had an end date, right? Which kind of brings us to the core of this current legal fight.
Exactly. Those original 2016 charters, they were set to expire December 31st, 2024. So as you'd expect, NASCAR started negotiating new charters for 2025 and beyond. By early September 2024, most teams, 13 out of the 15 charter-holding organizations, they'd signed the standard 2025 agreement. But the plaintiffs in this case, 23XI Racing and Front Row Motorsports, they chose a different route. They declined to sign, and instead, they dropped a bombshell, a major antitrust lawsuit. Their claim is that NASCAR violated the Sherman Act, basically using anti-competitive tactics to maintain a monopoly over what they argue is the only premier stock car racing series out there.
Wow. So with their whole racing future pretty much on the line, 23XI and Front Row took the fight off the asphalt and into the courthouse.
Right. They had two main goals with that motion, two really pressing objectives. First, they wanted some immediate help dealing with the consequences of suddenly not being chartered teams anymore for the races coming up. But maybe even more critical for them, they wanted the court to stop NASCAR from selling their old charters to other teams. They basically argued that if NASCAR sold those charters, it would, and this is their phrasing, for all practical purposes end their existence as a realistic competitor in the Cup Series. Essentially, they saw it as a potential death blow.
And this kind of legal move, asking for an injunction, it wasn't entirely new in this specific case, was it? I think the court had already looked at injunction requests before.
That's right, yeah. This whole legal saga has had a few twists regarding injunctions already. This same court, Judge Bell's court, had actually granted the plaintiffs a preliminary injunction way back in December 2024. That order allowed them to keep racing as chartered teams while the main antitrust case proceeded. But then that specific injunction got overturned, vacated by the Fourth Circuit Court of Appeals just this past June. They cited some relevant legal precedent, and that reversal by the higher court is what directly led the plaintiffs to file this current new motion for a preliminary injunction. Trying again, essentially. And it's also worth remembering, even before that, back in July, the request for a TRO, a temporary restraining order, which was part of this same motion, that was also denied, largely based on some initial promises NASCAR made to the court.
So yeah, definitely not their first attempt at this kind of immediate court intervention.
Not at all. They've been pushing for this kind of temporary protection for a while.
Which brings us right to the core of what we're unpacking today. U.S. District Judge Kenneth Bell's decision. The court denied the plaintiff's motion for a preliminary injunction. They didn't get that immediate relief they wanted. So what was the judge's main sort of foundational reason for saying no this time?
The absolute key reason, the foundation for the denial, was the judge finding an absence of irreparable harm. Now, that's a critical legal standard. To get a preliminary injunction, you generally have to satisfy several factors, often called the winter factors from a big Supreme Court case. You need to show you're likely to win the case eventually, sure, but crucially, you also have to show you're facing harm right now that is so severe it can't just be fixed later with money damages if you win. Plus balance of equities and public interest factors. The standard's even higher, heightened, as the court says, for what are called mandatory injunctions, where you're asking the court to force someone to do something, not just stop doing something. In this situation, Judge Bell looked at everything and concluded the plaintiffs just hadn't cleared that irreparable harm hurdle right now.
Okay, so no irreparable harm. That was the linchpin. Let's break down why he reached that conclusion. Their first big worry was just being shut out, right? Unable to race in the Cup Series at all. What did the judge find regarding their ability to actually compete for the rest of this season?
Right, and this is where NASCAR made a very significant move strategically. NASCAR told the court it had changed its open racing rules, and the change was specifically designed to guarantee that the plaintiffs, 2311 and Front Row, could fully participate in every single one of the remaining Cup Series races for this 2025 season. Now, the judge even noted the irony here. He pointed out that NASCAR's very ability to just make that kind of rule change mid-season kind of highlights its full private control over who gets to race, which is sort of central to the plaintiff's whole antitrust argument. But the immediate practical effect was the plaintiffs will be able to race. So the judge concluded, okay, there's no irreparable harm on that specific point for the rest of this season. As for other potential harms, like losing the fixed charter payouts or dealing with uncertainty from drivers and sponsors, the court basically said those are either things that can be compensated with money damages later if the plaintiffs win a trial, or they're just inherent risks you take when you file a major lawsuit like this. So not irreparable in the legal sense needed for an injunction right now. He was also careful to point out that the situation for the 2026 season, that's totally unsettled for everybody, and this ruling doesn't touch that.
Okay, that deals with racing this year. But like you said, running a team isn't just week to week. It's about planning, long-term sponsors, driver contracts. That strategic uncertainty must be huge. And what about their other big fear? That NASCAR would just turn around and sell off their old charters, potentially locking them out permanently? How did the court handle that?
Yeah, that was arguably the bigger, more existential threat. They raised the idea that their former charters could be gone forever, making a return to full competitiveness impossible, even if they eventually won the lawsuit. And this is where NASCAR made another set of really crucial commitments directly to the court. These were important. NASCAR basically promised two things. One, it will not sell or convey the disputed 2025 charters. That means the specific charters previously tied to the plaintiff's cars and the related Stewart-Haas cars, numbers 23, 35, 45, 4, 34, and 38. Those are effectively frozen. Two, NASCAR also promised it will not sell, convey, or lease more than 4 additional charters, meaning brand new ones, numbers 37 through 40, beyond the existing 30 active ones and the 6 disputed ones.
So hold on. And NASCAR basically agreed to put those specific contested charters on ice, to not touch them while the case proceeds.
Exactly. They committed to maintaining the status quo regarding those specific crucial assets. And because of that commitment, the judge concluded that as long as those disputed charters remain available, available for the court to potentially use as part of the final relief granted to plaintiffs if they are successful at trial, then there's no irreparable harm from their potential sale right now. He also noted that the underlying 2025 charter agreements do allow NASCAR to create up to 40 charters in total. So NASCAR adding a few new ones, like 37 through 40, doesn't, in the court's view at this stage, irreparably harm the plaintiffs specifically. And this is really significant. The judge heavily emphasized the court's own broad power to craft what are called equitable remedies if the plaintiffs do eventually win their antitrust case at trial. He mentioned things like potentially terminating illegal monopolies, taking away ill-gotten gains, ensuring future competition, even forcing sales of assets or mandating licensing on reasonable terms. He cited several major antitrust cases as examples. So the court basically said, look, we have plenty of tools to fix this later if we need to, even without granting this preliminary injunction right now. It shows the court's confidence in its own ability to sort things out fully after the trial.
Okay, so this ruling really is just setting the stage for the main event. The trial on the actual antitrust claims is the big race here. What happens now in the immediate future?
Think of this ruling as managing the situation until the trial, not deciding the winner. So for right now, the status quo continues, but with those specific guarantees in place. Plaintiffs, 2311 and Front Row, they'll keep racing as open cars for the rest of the 2025 season, thanks to NASCAR changing those rules. And critically, those disputed charters, the ones formerly linked to cars 23, 35, 45, 4, 34, and 38, they stay put. NASCAR won't sell or transfer them before the trial concludes. But again, this ruling says absolutely nothing definitive about whether NASCAR's actions actually violate antitrust law. That's still completely undecided.
And the trial itself isn't that far off, is it?
No, it's coming up fast. The judge noted it's less than 3 months away. So the real showdown over the merits of the antitrust claims, whether NASCAR did engage in anti-competitive behavior, that's imminent. This preliminary injunction ruling was purely about temporary relief, about managing the situation before that main event. It wasn't a judgment on the final outcome. And the judge was really explicit about this. He actually said he thought it was best not to provide his forecast of the plaintiff's likelihood of success on the merits because he didn't want to potentially bias the future jury pool. That really underlines it. This decision was strictly about the lack of irreparable harm right now, based largely on NASCAR's promises, not about who's ultimately right or wrong on the bigger antitrust questions. Both sides are now gearing up to present all their evidence on market power, competition, the impact of the charter system, all of that. It's going to be intense.
That's a really important distinction. So let's recap the key takeaway here. While 2311 Racing and Front Row Motorsports didn't get the immediate injunction they were seeking, the court's decision seems to really hang on those promises made by NASCAR. Promises to let them race this season as open cars, and crucially, the promise not to sell off those specific disputed charters for now. And that keeps the door very much open for potentially powerful remedies later on, if the plaintiffs manage to prove their core antitrust claims at the trial. It means this fight over the team's future, and maybe the whole structure of the sport, is definitely far from over.
Yeah, absolutely. And this whole situation, it really raises some fundamental questions for anyone interested in NASCAR beyond just the legal nerds. When you see NASCAR demonstrating this full private control over the rules, being able to change participation guarantees mid-season like that, and you combine that with how absolutely central these charters clearly are for team survival and success, what does that mean long-term? Are we witnessing the start of a legal challenge that could genuinely reshape team ownership, the nature of competition, the whole structure of professional stock car racing as we know it? It's just a fascinating glimpse into how the real rules of the game are being contested, not just on the track Sunday afternoons, but with incredibly high stakes in the courtroom, too. It's a battle for power as much as points. Thanks for tuning in to this week's Kick in the Tires podcast.